Well, good afternoon. This is the November 2025 edition of the second Wednesday series. My name is Paul Millenbach. Good to see you all again, or not see you, but know that you're here. With me today is Cliff Hammond. Cliff and I have spoke about labor and employment issues in the past, and Cliff is back today joining us. Thank you, Cliff. Cliff is a labor and employment specialist at Foster Swift. He works in the firm's Southfield and Lansing offices. He's very well versed in all issues related to labor and employment, and there certainly have been some changes that occurred in the early part of this year of 2025 that we spoke about previously. And today, given that it's close to the end of the year, Cliff is going to talk about what we've called critical year-end housekeeping essentials for employers as it relates to some of the new law that went into effect this year, as well as some of the old law that's been in effect for a very long time. So without further ado, Cliff, let me just please introduce yourself to everybody and we'll get started.
All right. Thanks, Paul. Yeah, appreciate it. Yeah, like Paul said, I do employment law and want to talk a little bit about what we should be doing here at the end of the year because there's been a lot of changes this year, right? There's been a lot of things. And so we need to make sure we keep our head focused on what we need to do as an overall view, as opposed to some of these, hey, let's just patchwork this up to fill the gap because of this new law or this new policy. Let's make sure we do a broader view to make sure we're entirely ready for next year.
Thank you, Cliff. Well, the first question I have is what type of documents or policies should employers be aware of and look to revise before the end of the year?
Yeah, it's a great question because a lot of times people forget what they have to do. They're thinking, okay, we want to do something, but what do we need to look at? So I always start from a 30,000 foot view. People always ask me, what do I look at? And they'll say, my handbook's old. And I'll tell you, the thing that people don't understand is actually there's no law in Michigan that says you have to have a handbook. There's nothing saying you have to have an actual handbook. Now, I think you're foolish if you don't have a handbook. That's my recommendation to everybody is make sure you have a handbook. But everything doesn't have to be in a handbook. We need to look at all of our policies, all of our procedures, all of the things that tell people what to do. So if you have a policy or procedure that talks about what we want for safety, what we talk about for wages, benefits, hiring, firing, what we do for our leaves, what we do for equal employment, what we do for drug testing, what we do for vacation policies. If people get hurt on the job, who do they report the injuries to? Again, our pay policies. How do people notify management if they have a problem with their pay? How about remote work policies, non-competition agreements, non-solicitation agreements, agreements about confidentiality? Those things could be lying anywhere in your operations. They could be in a file cabinet. They could be on a computer. They could be on a portal. They could be in your handbook. What we want to do is we want to take a look now at the end of the year and say, what are our policies? Maybe we have policies we don't even know. I've talked to a lot of clients and said, I think we got a policy on that. I don't know about reporting injuries. I don't know if we have a drug testing policy. I don't know if we have an EEO statement or an equal opportunity statement or non-discrimination policy. So now's the time to find out what type of policies do we have out there in all these different places. We may have internal policies. We might have external policies, right? Things we give employees versus things that we give our management and our staff in the HR department. So that's what we need to be looking at. We need to look at how we run our business from an HR component, all the things that may be in a handbook, should be in a handbook, but might not be there.
Is there anything critical about year end? Is there a reason why we want to look at it at year end, or is it something that can be looked at in June or July, or are we looking at it at year end because we want to kind of create a schedule and do things at a specific time?
That's a good question because it always goes on, right? It's not like we have a year-end requirement. The government doesn't require it unless there are laws going into place in January 1. Historically, what happens is at the end of the year, a lot of times you'll have new bills, new policies, new procedures that go into effect January 1. So you'll see that as being a lot of historical reason why we do that. The other reason is you want to start off the new year right? Let's clean the slate. We had an easy year, we had a tough year. So why don't we just go ahead and look back for the last year? But you might say, you know what, at the end of the year, it's too busy. It's too hectic. We're trying to do a lot of things. We're trying to close out things. But a lot of times what happens is because we do a lot of end of the year type activities, it's a great time to interact with our managers, great time to look back at the notes that we have, the successes, the failures, all those things. That's why a lot of companies look at the end of the year as a great opportunity. It's time to now start the new year off right. But you could do it at the end of your fiscal year. You could do it at the end of March. You could do it at the middle of July. But the end of the year is a great time to try to put that policy and procedure in place effective January 1. Or maybe not. Maybe you just simply say, let's do a to-do list or a meeting and move forward.
You indicated at the beginning, Cliff, that a company doesn't need to have a handbook,
Mhm.
but you recommend that they do. I mean, obviously, that dictates how the company's going to operate from an HR standpoint with policies and procedures. Are you familiar with any companies that don't have a handbook and the kind of problems that have arisen when that occurs?
There are a number of companies that don't have one. What they have instead is effectively a policy procedure manual that will be available online or separate policies they have. They don't call it a handbook, but in effect, it is a handbook, except it's not in one place. So think about it from this way. You could have 15 different policies. Employees just go online, they acknowledge their existence, they make sure there's a record of it, but they don't have an employee handbook. And one of the reasons why a limited number of companies do that is they don't like to have one working stale handbook. They want to have a bunch of independent policies that they can take and give to employees and say, we're talking about this. We're not talking about something else, because they don't want their employees roaming around looking for something to argue with them about. And they think it's just more efficient for them. So it's up to you to decide as a company which one you like better. I like it in one place because here's the reality. When you're in the middle of the week and you're trying to find something, how much easier would it be to have an index on one document to go look through it, whether it be a handbook, a policy, or procedure? So that's why a handbook, in my opinion, is the best for managing a company, unless you have great technology or great people with rote memories of everything they've ever done. That's why I say it's not a legal issue. It's as long as you have all the policies you need, you can put them wherever you want. It just makes it easy.
And in your experience, have you found that dispute resolution or problems that might arise are much easier to resolve if there's a handbook or not?
Well, the handbook is the number one way that we look at policies and procedures. So it's usually the way that you resolve it is you just pull the handbook out. And people will say, well, where's that in the handbook? I've actually had that. You pull the handbook out, you show it to them, quiets them down, right? It resolves the situation. And that could be a two-way street. Sometimes the manager says, our handbook says this. You get the handbook, it doesn't say it. So that resolves the problem in the employee's favor. It literally can go both ways. But that's as easy as that can be. And I can tell you in a non-union setting, when you have just the handbook right there, it sometimes it gets lost. But in a union setting, people will say, look, a management will just simply run the contract and say, look, I can have whatever contract you want, but I will make sure you will abide by this contract. And it makes it easy for them. Same thing can happen with a handbook. If we have a nice handbook, well done, got our policies, procedures, expectations, it makes the manager's job a lot easier to be able to point right there to the employee and say, this is why you have to do what I ask you to do.
Well, let's talk about a nice handbook. Are the handbooks themselves are something that are they negotiated between the employees and management, or does management more or less draft them themselves and present them to the employees without any type of input, or is it or
Yeah,
both?
that's a good question. Generally, they are the employer's opportunity to say, this is the law of the land, right? This is your opportunity to say what your expectations are of the employee. And that's what you should think about it as, unless you're in a union shop where you have to negotiate a contract or changes. And even in those cases, generally there's management's rights to adopt policies and procedures. They respect the management's rights to say, this is the rule, this is what we want. It is the map, right, for employees to operate. This is how we want you to handle certain situations. In litigation, like you were talking about before, it's also the map to show, hey, you had an obligation to do X, Y, and Z, and you didn't do it, did you? Because this is what you had, this, and you write, hey, look, I acknowledge I had this policy procedure. So when we draft it ourselves. Can you take employee input over the course of the year and put that into your thoughts? Yes. But ultimately, it is an employer document. And that's how we should address it. This is what we want within the confines of reality, right? You can't say things that are illegal. You can't say things that are not realistic. And one of the things I always look at is we look back when we revise our handbooks, and I ask people, I know what your handbook says, but what do we really do? Because some of these handbooks are old and they haven't been revised in 100 years. And they say report to so and so. That position hasn't existed for 20 years. right? So that's part of the house cleaning that you do when you revise your handbook. Right positions, right policies, draft it the way you want it, because at the end of the day, since you're the one who drafts it as an employer, you're going to be bound by it. So make sure you take the time to do it right.
Well, looking forward to 2026, what are some additions that should be put into handbooks because it's 2026, because it's a new year and we have new laws that are in effect?
Right. Well, you have your policies, you have your procedures that are general, but things that we need to have are things like equal employment opportunity. Why do we do that? Well, if we ever get sued, we want to say, no, 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 we don't discriminate. We don't, treat people differently. We've got a policy on that that says we don't do it. And if people have a problem, they bring it to this person, and then they go to this person, and this is how we handle those. So it helps us, right? So that's the number one thing we want to do. Make sure we. Then I look at anti-harassment, anti-discrimination. I look at your reporting injury policy to make sure we have a good policy, make sure people are reporting their injuries on time and that our managers know what to do when they have them. We have our safety policies in place. Drug testing is a big one. We have to make sure we are updating our drug policy, our hiring policies, our leave and vacation policies, which goes into the one that's the big one, which we talked about earlier this year, which is Michigan's new Earned Sick Time Act. And we have to make sure we have a policy that is up to date and compliant with our leave and our sick time requirements. We want to make sure we have our pay record policies, because that's very important. Fringe benefit and insurance policies. Now, remote work, a big deal. Who's working from home? Can you make them work from home? How much can they do that? And again, your restrictive covenants, you're making sure you keep our information confidential, your non-competes, non-solicitations. Now, those shouldn't be in your handbook, frankly. They should be a separate document. You can put stuff about confidentiality in there in the handbook or a policy, but I like to have those separate and distinct from the actual handbook, because remember, a handbook's not a contract. That's important to remember, right? So we talked about, can we draft it? Yes, but it's not necessarily, the thing that you have. But I will tell you, you look at everything, but those are the things that I see as being the low hanging fruit that we can make sure we have. The things that we talk about here, making sure people understand what to do, what our drug testing requirements are, safety, time off, our work rules, those kind of things. Make sure they're all in line with reality.
You touched on ESTA, the Employee Sick Time Act, that went into effect in 2025. I believe that was late February. Am I right on that?
That's correct. Yeah, for
And,
most employers. Yeah,
and
small
since
employers.
that, oh, go ahead.
I would say small employers in October, but yeah, for everybody else. Yeah.
Okay. If an employer wants to make changes to a sick time policy, or doesn't like how things have been going since ESTA, would this be the time to do that, or would they have to wait a year in order to
Do
do
whatever you want. Yeah, you can make those changes whenever you want. If it's not working, it's not working, right? So it's okay to say, I put this policy in February and it's a disaster, or it's just not working out. Let's put a new policy in now. The only thing is, you have to make sure that people don't get shortchanged because of the change. They still need to get those 72 hours if they're a large employer, or 40 hours. They can't be shortchanged. They can't lose time. So you have to talk about a transitional issue, but you can change it now if it's not working, or you can wait till a year. It's up to you, but you can do that this minute. It's now a good time to evaluate. We've had some pretty good sample sizing to figure out whether it's good or not, and now let's go ahead and go forward with it.
Have you seen in your practice, have you seen a lot of companies want to make changes?
Oh
to
yeah,
that?
yeah. Oh yeah, people were wanting to make some changes, and that's not like it's a wholesale change, but it's just minor changes. Some hey, look, we wanted to do accrual. We don't know how to keep track of hours. It's a disaster. So let's just give them up front starting the next year. Once they hit their next year, we'll just give the money up front, the time off up front. I'm sorry, and then we don't have to worry about carryover and all these other capping issues. It just makes it easier. That's the one that I'm seeing the most.
You spoke a little bit about handbooks, or a lot about handbooks versus policy versus standalone documents. What different types of things should go into each category or each kind of bucket? Is there certain things that should be in a handbook that are different from what should be a policy, that are different from what should be a separate document?
Yeah, that's a big deal. I mean, actually, this is one of the biggest issues you can have. So remember, there used to be a Michigan law that effectively said that a lot of handbooks were contracts, and you were bound by it. And if you didn't, as an employer, do what you were supposed to do under the handbook, that's a contractual issue. So your sick time, your work rules, things like that. That's changed now. It's actually the exact opposite. You got to work hard to make it a contract. But what you don't want to do is create a contract by having people sign it and then putting your non-compete provisions. See, it makes it harder when you tell people in the handbook, this is not a contract, and then try to hold them to it. Right. So you don't want to do that. So what you do is you can lay out your general policies, expectations, and procedures. But if you want to take money out of somebody's check, for instance, because they didn't pay their insurance, or if you want to take it out because they've used more vacation than they earned, okay? So you want to take that out of their check, you have to have a signed authorization. Signing a handbook is generally not going to get it done. So you want that separate and distinct, that authorization form for them to have money taken out of their check. The same, now that's not for taxes. Taxes you can take out, and for your insurance, you generally just take it out because they sign it up in open enrollment. But it's those fringe issues that we want to make sure we have. The other things are your confidentiality agreements. I like those separate, right? I like to have the non-competes, the non-solicitation of your employees, the non-solicitation of your customers. Make those separate and distinct agreements as opposed to in a handbook or in a policy that's a general policy. So you can enforce them. So you can go to court. So you can use them individually. And even though it's not a separate policy, I always say keep that acknowledgement page, the one that's saying I acknowledge that I got this, keep that separate from your handbook. Because a lot of times there's one thing that you want to do. Sometimes people say, I don't want to go to court if I can avoid it. I don't want a public display. I'd rather go to arbitration if an employee has a problem. Well, that needs to be in a separate document as well, because that's going to be an agreement or a contract. So again, just remember what a handbook is. It's policies, but not a contract. The things you want to enforce, though, you want to put those as standalone from the handbook.
Oh, that's good advice, Cliff. I didn't realize that there is a distinction between the two. That's helpful. What are some of the ways or some of the policies, and how do those assist in lawsuits or audits?
Well, the same thing we just talked about, right? So let's just say you have an audit and the Department of Labor comes in and says, hey, by the way, we looked at it and you didn't pay a bunch of overtime to a whole bunch of people. And you have the requirement as an employer to keep your records, not the employee. It is your job to make sure things are done. And they say, well, Johnny and Susie, they say that they worked overtime. And you say, well, wait a minute now, I've got a nice little policy here. And it says that you are to report all your time on a time card, right, every week. And then you're supposed to read your paycheck or your pay stub and then report within X days if you have any issues with it. So we have a very clear policy about what's supposed to happen, and we relied on their individual discretion. Doesn't get you out of jail free, right? There's still opportunities for them to sue, but it really helps you out. The same thing goes for everything you do in litigation. The first thing you do is you say, during a deposition of somebody suing you, you say, hey, is this your signature or acknowledgement? And they say yes. And they say, okay, so you acknowledge the handbook. Now let's go to this page. And it says, if you have a problem or a disability, who are you supposed to report it to? Oh, well, I go to so-and-so. Well, you didn't do that, did you? You didn't follow this procedure. So all of a sudden it undermines their credibility. Again, not to get out of jail free card on everything, but it's very helpful. But with litigation, sometimes people say, I'm going to go to court. I'm going to get a crazy jury. They're going to give me $500 million like that billboard I saw coming to work today. And I'm going to win $500 million because you discriminated against me. And he said, whoa, not so fast now. You signed this arbitration agreement. Now, not arbitration agreements aren't as enforceable on some things as they used to be, but it could all of a sudden get it out of the jury's hands and into an arbitrator's hands who might be a little bit more reasonable. So these are the types of things we want to put in place. Our policies are there to protect us, and the execution of the acknowledgement helps us show that the person got it. Now, one of the things that comes up sometimes, people say, well, what if I gave Johnny a handbook and Johnny said, I'm not signing that? Now, is he still bound by the handbook and the policies? Yep, he is. But he may not be bound by the other things we talked about, right? The non-solicitation and the policies like taking money out of his check, right? Non-competition agreements, the arbitration agreements of the world. Those are contracts. If he doesn't sign those, it's a problem. But I always say, In a non-union setting, if somebody comes in and you just simply give them a policy and they say, I'm not going to sign that, you say, okay, we'll find another job.
That was my next question. Were you able to discharge them if they won't sign the contract or won't
Yeah, I
sign
mean,
it?
you shouldn't just simply say, sign it or you're out. I would give them a chance or two or three, right? I would say, look, but not too long. I mean, I wouldn't, because if you're not going to abide by my handbook, then how do I know you're going to abide by my work rules? I mean, some people just say, well, I don't care, and you say, it's an at-will relationship unless you have an employment agreement. And this is very important to look back. Your employment handbook doesn't trump a union contract and generally will not trump provisions in an employment agreement with an employee. So you have an employee with an employment agreement. The employment agreement says you get 20 days of vacation. The handbook says you get 15. You're going to give them the 20. They're going to be able to enforce that. It says that they get time off whenever they want. Your handbook says you got to get 60 days notice. If it's specifically in conflict, generally that employment agreement will win.
All right, thanks. One of the things that's been getting a lot of talk lately is return to the office policies. And is that something that can you give us some guidance on if an employer wants people to no longer work remotely and return to the office, what they should do in that instance?
Yeah, one of the ones you should be looking at right now, right? If you're a company that has had people out and about doing whatever they're doing and they've worked remotely, whether it's good or bad, this is the time to kind of look at it because the market's shifting, right? The market's getting people back to work. Many companies are pulling back. I mean, some people are loving it. Some people are just clawing and screaming, yelling. There was a case before COVID hit that said that an employer can make in-person work an essential function of the job. They can say, because we want you to be in, because we have reasons why, that's important, that's essential, and that you can require that to happen. And employees sometimes will say, I don't want to come back to work. And unless there's a reason, generally speaking, you can simply say, I'm sorry, you can't do it. If a person says, well, look, I got to pick up my kids, I got to do that. As an employer, just picking up your kids is not a protected activity. It's not something under the law that you have to allow. Now, where you could have a problem is you let Johnny go play golf whenever he wants to, but you don't let Susie go pick up her kids. Now, all of a sudden, you got an issue. Is it because it's a real rule, or are you just saying, I don't want people that have kids, specifically, I don't want women, to go out and leave? And so they could have a discrimination case. Unequal enforcement is the problem. The other issue you have is people say, "Wow, I got a disability. I can't sit at home." Well, the case that I'm talking about was a case with Ford, and basically the person said I had a disability, and Ford went back and forth with them. Well, they had a problem. They had to go to the bathroom all the time. They said, "No problem. We're going to move your desk right next to the bathroom." Good news. You're good to go.
Mm.
They said, well, no, I that's not what I want to do. And they work with them back and forth and back and forth. They went through what they call the interactive process with the person. And they eventually just couldn't do the essential function of the job, which is in-person work. So it's a fact specific issue. You can't just say no. You have to look at what you do with everybody else. You can't treat people differently. And that's the hardest part about this is I tell people your policy can say whatever you want, but if you don't enforce the thing across the board and you let people have their own exceptions, it could cause you problems. Now, exceptions based on a disability is one thing, but if it's an essential function to come in, it's an essential function to come in. So when you draft your policies, you look at it, do we need people in or do we want people in? That's the first question. Then the second question after is, do we need or want people in? Then we start saying, okay, what if this happens? Is this the type of job that I can do remotely or not? And do I want to make sure, at least for this position and these types of positions, this is what we're going to do? Because you will get claims for this is just not accommodating me. And I have those all the time. So you have to look at it. And there is no one-off answer. We have to look at all the circumstances.
Thank you. We're running a little bit short on time. There's some questions. Let me see if I can access those real quick. The first question is, since this company has never had an HR department before, what protections do I have as the HR manager when implementing disciplinary actions and staff's attempts to retaliate because of those decisions? I make sure to document everything thoroughly and keep detailed notes during investigations, but is there anything else I can do to protect myself professionally?
That sounds professional, like you're doing what you need to do, right? I mean, as HR staff, what we do is we promulgate work rules that are reasonable, non-discriminatory. We take good notes. We make sure that we're enforcing them even-handedly. And those are the types of protections you want. There's no protection against somebody saying, well, you did it in retaliation for me doing something, right? There's a retaliation process, a whistleblower, something of that nature. And if you're not enforcing it even-handedly, then you might have a problem. But again, basically, my advice to everybody is make a policy that's non-discriminatory, enforce it even-handedly, and people can sue for anything. I mean, you can't stop them. Frivolous lawsuits happen all the time. Bad lawsuits happen all the time. But our goal is to do exactly what you say you're doing. Document policy, notify people before they get the policy's effective date, and then move forward. If you're in a at-will situation with employees, it really is that simple. People don't like it, but that's our policy and procedure. Again, it has to be lawful. We can't have policies and enforcement that's against the law. But as long as it's within the confines of law and you're doing your job, that's generally all we expect. That's what you have to do.
Thank you. When changing handbooks, do you need to post changes with notice of when effective? For example, 30 days prior to being effective?
Well, there's no law that says you have to, but there's a general rule of thumb that I always use. You can't make people change their behavior unless they know to change their behavior. So I always say we promulgate the handbook, we issue it. Now, whether that's in person, face to face, or whether that's electronically, and then we give them a little bit of lead time, a week at least, a couple days, a week probably makes sense. 30 days is actually great. But I wouldn't give them 6 months or a year, right? I mean, you don't have any obligation to do that. You can change it on the fly, but you want to be realistic, right? Realistic to say, okay, we got a new handbook when everybody get on, the right page. And so, yeah, I think opportunity to know what your rules are, make sure everybody's signed off on it, and then put it into place.
And you don't have to open it up for comments or any type of input. You could just provide the notice and this is what's going to happen. And we talked a little bit about that earlier, correct?
Yeah, that's absolutely true. Yeah, and that's one of the things people get themselves in trouble with is, all right, everybody, what do we think about this? Well, I don't know. If I was doing it, I would have done it this way. Well, I don't care what you want. It's unfortunately running a business isn't parliamentary most of the time because if you do it that way, you get like, I don't know, Congress, and you just have things drag out forever, and it's a disaster. You want your rules to be reasonable on behalf of the employees. You can take during the course of your discussions, you can, take into account what people have said to you. But at the end of the day, it's not a negotiation. Again, in a union setting, it's different. But in a non-union setting, it's management doing what they think is best and then rolling it out. Again, an employee might have a concern they raise after you roll it out and you go, never thought about that. But it's not because you had like a meeting, scheduled meeting with everybody to go over. You can have a meeting to talk about it, but I wouldn't do it before you roll out the rule.
Good. The final question is, do employees need to sign receipt of a handbook every year or just when hired? Or need to sign it at all?
I would have an acknowledgement, whether it's electronic acknowledgement or a written acknowledgement, every time you have a handbook that's redone, right? So let's just say in 2025, we roll out our new handbook. We don't change that thing until 2090. You don't need another signature. If you update an individual policy, but not the rest of the handbook, just make sure that it's given to people and you have an acknowledgement of that particular section that's been updated. If you roll out a new handbook with a couple new sections, everybody needs to sign up then. So it's whenever you make changes, that's when you need the acknowledgement. If you don't change anything, then you don't need acknowledgements.
Okay, there's no yearly annual requirement that it be acknowledged, correct?
Only if you change things, right?
Right. Okay, thank you, Cliff. I believe that's all we have today. I think I've covered everyone's questions. And on the chat, there is Cliff's contact information, his phone and email address. If you want to reach out to him, feel free to do so. Our next second Wednesday is on December 10th, and please look out for the subject of that, which will be coming very soon. Thank you.